Hey everybody, Bobby Klink from Your Online Genius here. Wanted to come to you on this Friday. I hope you had a great week. I wanted to help you out and address four big copyright myths that I see over and over again. And these are myths that are pervasive and can really get you in some trouble. So I wanted to address those to help people stay out of trouble. Before I do that, though, again, a quick introduction. If you don't know me, I'm Bobby Klink. I'm an online entrepreneur and an intellectual property lawyer. I'm the founder of Your Online Genius, which is a business that helps entrepreneurs take care of their legal stuff themselves. Basically, we help you figure out what you need to do, how to do it, and get it all done. So that's what the company's about. That's what I'm about. Like I said, today I wanted to address issues related to copyright law. And I wanted to do that because these are issues that come up over and over and over again. And really, I wanted to do it because for an online entrepreneur, quite honestly, copyright law is one of the most important areas. I hear it all the time when I have polled my audience. I often hear people are worried kind of about both sides about copyright. One, how do I protect my stuff? And then second, how do I avoid being accused of infringing other people's stuff? So it's an issue that I know people are worried about, so I want to make sure and address it. Put out a blog post earlier today that has a lot of the same information, but I want to do a live because I know some people would prefer to actually come and listen rather than have to read it. So what I'm going to do today is address, like I said, four of the biggest, kind of most pervasive myths I see. Now, these all really are about the second piece, not about protecting your own content so much. It's more about not stepping on someone else's rights. And I always like to address those things first because, quite honestly, I think entrepreneurs often worry a lot about protecting their own stuff. And so they take action there, but a lot of times they aren't taking the right action to not infringe someone else's rights. And so I want to make sure that you have that information and understand how important it is to do that. So that's what I want to address. Also, these are things that I hear over and over again, so I wanted to address them. So without further ado, let's dive into the four myths. Now, the first myth is what I refer to as the 7-second rule. The concept behind this myth is that you can use just a little bit of a copyrighted work without getting permission. So I refer to it as the 7-second rule because I've heard people say that they understand they can use 7 seconds of copyrighted music, like up to 7 seconds without getting permission. Some people have said 5. I actually had one entrepreneur, a podcast host that I was on, say that they had heard 30 seconds, but it's all the same and it's all wrong. The fact is there is no exception to copyright law that says you can use just a little bit. It just doesn't exist. If you use any portion of a copyrighted work, the presumption is that you have infringed that copyrighted work. Now, I'm not sure, but I think this myth comes and is really kind of derived from a very complicated doctrine that is actually the fourth myth, which is fair use, which I'll talk about later. But you don't want to find yourself relying on fair use. So we'll get to that in a minute. But the point of the 7-second myth that I want to make sure you understand is that you can't say, well, I can use just up to 7 seconds or up to 5 seconds or up to any specified amount of a copyright work. It's just not true. If you use any portion of a copyrighted work, you have infringed that copyright, again, unless you can find some other exception that gets you out of it. So don't buy into the 7-second myth. It's just not true. Now, the next myth that I want to talk about is what I call the notice myth. And this is a myth that, it has its roots in history, but I have to say, sadly, I've seen lawyers continuing to advise people of something that leads them astray here. And this myth is that you have to give notice that your work is protected to protect it. And so then the problem that creates is that people then believe that if something doesn't have notice, they're free to use it. Now, where does this myth come from? Let's start back in history. Back before 1978, you always had to give notice that something was copyrighted or you would lose protection. Then there was this period from 1978 to 1989 where there was kind of this hybrid rule, but you potentially lost protection for your work if you didn't give notice that it was copyrighted and that you had protection. But that rule was taken out of existence and does not apply to any copyrighted work that was made on or after, I think it's March 1st of 1989, but at some point in March of 1989. So any work that's been created basically in the last 30 years, you don't have to give notice of. You get protection no matter what. Now, if you think about it, it's still good practice to do it. So this is a good piece of advice or piece of pointer for you in creating your content. Look, you look at my website, you're going to see I have a copyright notice on it on the bottom. You look at any one of my books, I have a copyright notice on it. Of course I do, because, there's no harm in including that. But the problem about the myth is that it makes you believe that, hey, I find something, it doesn't have a copyright notice, I can use it. That's just not true. So don't believe that myth. If something falls within copyright law generally, which means it's a creative work of any kind, you can't use it without permission. And it doesn't matter if there is a note of or a notice on it or not. So the notice myth will lead you down the wrong track by suggesting to you that you can use things that you're not allowed to use. So don't buy that myth either. Now, that brings me to the third myth. And the third myth is actually kind of a collection of myths. It's myths about stock images. And there's a couple of varieties. And the first variety is a belief that you can use images that fall into certain categories without any copyright. So some people, seem to think that, hey, if it's on Google Images, I can use it. Or, hey, somebody put it on Twitter, I can use it. That's just not true. An image does not lose copyright protection because it's posted on the internet or because it's posted, on someone's social media. That doesn't take away copyright protection. You have copyright protection all the time, every time you have it, period, on an image. So that means you can't do what I refer to as the right-click save as problem. Some people, they're on Google Images or they're on a website they like or they're on social media. They see an image, they put their cursor over it, they right click and go to the save as, and they take that image and save it for later. You can't do that. That image is protected by copyright. You are not allowed to use that image without getting what's called a license, which is permission to use it. So that's the first type of myth around this, which is people sometimes think that for one reason or another, something's been posted, they can use it. Now, the next myth about stock images is that all licenses are created equal. So some people believe, hey, if I got a license, I'm good. I can use an image for anything. And I can understand why people believe that. You think, hey, I got a licensed image, I'm good. Well, you've gone the first step there. But the problem is you have to make sure that you're getting the right kind of license. And there's really three things you need in the right kind of license. One, you needed to say it's royalty free. Two, you need to say that commercial use is allowed. And three, you needed to say that there is no attribution required. Those are kind of the three keys. I'm not going to go into detail onto that because I've got a lot of things. There's a resource in the post if you want. I've got an ultimate stock image guide that has that information, goes into more depth about why those three elements are important, and even provides you with a dozen free stock image sites where the license, fits the bill. And I've reviewed it and it's good. But the point is, if the license doesn't have all three of those attributes, you're asking for a problem. So make sure that any copyright or image license you get is royalty-free, commercial use allowed, no attribution required. So that's the stock image myth. If you only get images from places where you're getting a license and it meets those three requirements, you're in good shape. So that takes us to the final myth. This one is not as pervasive, but I hinted at it earlier. It's the fair use myth. And so a lot of people, or not a lot of people, but some entrepreneurs will throw out this, oh, it's okay, it's fair use. And it's bad enough that they do this for themselves. But unfortunately, I will see these discussions in Facebook groups and these other things where someone is advising other online entrepreneurs, oh, don't worry, that's fair use, you can use it. Don't listen to people who tell you that. What I'm going to tell you is, look, is fair use a legal doctrine that applies in copyright? It is. Is it possible that you could use someone else's copyrighted material and it would constitute fair use? It's possible, but it's never going to be clear. outside of very defined things, like, for example, doing a review of a book, you can, include a little bit of the book when you're doing a review. But outside of those very clear contexts, it's not clear. And what that means is what you as the user might believe is a fair use, the copyright holder is going to believe is copyright infringement. And lawyers make their living fighting over what constitutes fair use. Lawyers will literally make a career out of this. I mean, copyright lawyers will spend lots of their time fighting these disputes. And the reason why is because fair use is, measured on this really convoluted, complex, multi-factor test, which essentially means there's no clear answer. So you're going to fight about it, and your lawyer is going to argue X, Y, and Z, and the other side is going to argue A, B, C, and you're going to have to fight it out. So what does that mean? That means, look, you may ultimately win the case. You may ultimately lose the case. You're not going to know in advance. But even if you win, you may actually lose the overall war, because you're going to have to spend a bunch of money on a lawyer like me. And what I want you to understand is the cost to fight a copyright case on fair use grounds is going to be six figures, because it's going to have to go a long way to fight over all these different issues of, is this a fair use or not? And so as a result, it's expensive, and you just don't want to be there. It's not worth it. You as an online entrepreneur and me, we have better things to spend our time, money, and effort on than a potential copyright dispute. So there is not going to be a case where it's going to be something that's worthwhile. Now, look, if you want to build a business model around using other people's copyrighted work and doing something with it. So if you want to do a satire show, if you want to do something like that, if you want to do a video clip show, you really need to talk to a lawyer. One-on-one, you've got to get advice. You need to have a good understanding of whether this doctrine is going to apply to your case or not. Otherwise, if that's not your business model, just don't plan to rely on it. Just say, fair use doesn't apply to me, or I'm not going to worry about it because it's not worthwhile. So those are the big myths. So the advice I like to give people is, look, assume that you cannot use any portion of a creative work created by someone else without getting permission. And that permission is a copyright license that has all the right terms of being royalty-free, being commercial use allowed, and no attribution required. If you adopt that general stance, you're not going to get yourself in trouble when it comes to copyright infringement. So take that stance. Just assume it and don't use anything without permission. If you do, you'll be in good shape. Now, again, I mentioned this during the stock image discussion. If you want to get a copy of my stock image guide, click on the link in the post. It will take you through Messenger. You'll get a copy of that stock image guide, which has, like I said, it goes into depth about the three elements of a license you want, and it gives you a dozen stock image sites that fit the bill. I've reviewed their license terms, and it has all three of those requirements. So you can say, hey, I can use these dozen sites, and I'm in good shape. So that's my call to action. But otherwise, just make sure that you're being careful in how you use other people's creative content. If you do that, you will stay safe and you'll avoid hot water from a legal perspective. So that's it for now. I'm signing off. I hope you have a great weekend. I'll be back next week with a couple of different lives. Definitely some good legal lessons coming, but some other things as well. But until then, I'm Bobby Klink, and I am going to go ahead and sign off now. Thanks.